right, so in HR, human resources, this is just a video about some of the employment laws that we're gonna be talking about. Give you a little preview here.
HR Basics is a series of short lessons designed to highlight what you need to know about a particular human resource management topic. In today's HR Basics, we explore employment law, providing an overview of the laws and regulations pertaining to the management of people in organizations. Employment regulations derive from laws passed by Congress, state legislatures, and local governing bodies. They also originate from executive orders of the President of the United States to manage the operation of federal government and its contractors. These regulations commonly focus on fair treatment of people in the workplace. Employment laws influence employee contributions to organizational performance by guiding managers in the management of people and organizations. Nearly all employment laws can be categorized in 4 areas of the regulatory environment. Here they are: equal employment, total rewards, employee safety and health, and labor relations. To begin, let's focus on regulations in the form of equal employment opportunity, or EEO laws, and other regulations related to fair treatment of employees. Equal employment opportunity laws prohibit specific types of job discrimination in the workplace. EEO laws and executive orders are intended to eliminate employment discrimination. The EEOC oversees compliance of these laws. 2 agencies oversee equal employment regulations. As we mentioned, the Equal Employment Opportunity Commission, or EEOC, is responsible for developing guidelines and overseeing compliance with most anti-discrimination laws. Then, the Office of Federal Contract Compliance Programs, or OFCCP, is responsible for the same activities relative to executive orders and work in the federal government. The primary objective of anti-discrimination legislation is to ensure that individuals are given an equal opportunity in the workplace. Title VII of the Civil Rights Act outlaws employment discrimination on the basis of race, color, national origin, sex, and religion in any aspect of employment, from being hired to being fired, and everything in between. These traits are called protected characteristics and are referred to as protected classes. Discriminatory practices can typically be grouped in one of 4 categories. First, disparate treatment, where an individual is treated differently because of the characteristic that defines their protected class. Second, disparate impact, a more subtle and usually unintentional form of discrimination that's also known as adverse impact. Third, harassment, which is unwanted and unwelcome treatment because of a protected class. And finally, retaliation. The law prohibits employers from retaliating against an employee for making a complaint of harassment or discrimination. Now let's move on to those laws that regulate compensation and benefits. Over the course of time, the administration of employee compensation, or total rewards, has been regulated by federal, state, and local governments. Let's take a brief look at the primary compensation and benefits employment regulations that you need to know as a human resource professional. Since 1931, 5 major pieces of legislation have shaped the fabric of how employees are paid, including, in 1931, the Davis-Bacon Act, in 1936, the Walsh-Hartley Act, in 1938, the Fair Labor Standards Act, in 1963, the Equal Pay Act, and in 2009, the Lilly-Ledbetter Fair Pay Act. The Fair Labor Standards Act, or FLSA, is administered by the Wage and Hour Division of the Department of Labor. The Act establishes standards for minimum wage, overtime pay, record keeping, and child labor. These standards affect more than 130 million workers, both full-time and part-time, in the private and public sectors. To learn more, see Greg's Part 541, Fair Labor Standards Act. I'll put a link to that video below. Equal pay laws provide that no employer discriminate between employees on the basis of sex by paying wages to employees at a rate less than that of the opposite sex. Although the Equal Pay Act was passed more than 50 years ago, a gender pay gap still exists. Females earn on average only 77 cents for every dollar males are earning.
That's because they're in different
Workplace
jobs.
safety law consists of federal and state regulations imposed on businesses in an effort to keep employees safe from harm. These rules apply to nearly all employers. Standards are in place to reduce the risk of accidents and illnesses in the workplace, and government agents have the authority to investigate violations and issue citations for noncompliance. Offenders are subject to monetary fines and in some cases imprisonment and other criminal penalties. The Occupational Safety and Health Administration, or OSHA, is the federal agency responsible for protecting the health and safety of workers. OSHA makes sure that employers follow occupational safety and health regulations and keep the workplace safe. For more about OSHA, see Greg Learning's HR Basics, Occupational Safety and Health Administration. I'll post a link to that video below. Workers' compensation law is a system of rules in every state designed to pay the expenses of employees who are harmed while performing job-related duties. Employees can recover lost wages, medical expenses, disability payments, and the costs associated with rehabilitation and retraining. The system is administered by the state and financed by mandatory employer contributions. States have enacted workers' compensation laws to replace traditional personal injury litigation to remove risk for both the employee and the employer. Laws regarding labor relations help maintain relationships with employees organized by labor unions, including the establishment, negotiation, and administration of collective bargaining agreements. 3 acts passed over a period of almost 25 years constitute the foundation of United States labor law: the Wagner Act, the Taft-Hartley Act, and the Landrum-Griffin Act. These acts are also known as the National Labor Relations Act, the Labor Management Relations Act, and the Labor Management Reporting and Disclosure Act. Each act was passed to focus on some facet of the relationship between unions and management. Jointly, they're referred to as the National Labor Code. For more detailed information on this National Labor Code, check out Greg's Learning's HR Basics Labor Relations. I'll post a link to that video below. Understanding employment law is critical for both employers and employees. Our 4 categories of employment law, equal employment, total rewards, employee safety and health, and labor relations, help frame our understanding. Employees should know their rights so they're not treated unfairly, and employers should understand employment law to avoid legal action resulting from ignorance or a lack of knowledge.
That video is up there, so if you want to watch it again. Or look at all those links that he talks about. All right. So I'm going to go through real quick some of the laws that they talk about in this chapter. Civil Rights Act of 1964, which was updated in 1991. ADEA, again, lots of acronyms here. I won't use the acronyms when I talk about them. Except for this one, FPR, that's this has to do with the veterans. IRCA, FMLA, and then these other ones. So let's look at these real quick. What I want to do, I'm not going to go into a lot of detail. You can read all the details. I'm going to have you guys in your groups choose one of these, or I'm going to give you in your group one of these laws to just real quickly do some research on and come up with a few facts about that law. So these fair employment laws: Civil Rights Act of 1964. This was a big one. You think about what was going on in the country at the time. The civil rights movement was going on. This was part of all that, which prohibited discrimination in hiring, firing, promoting, or compensating based on these attributes: color, race, religion, national origin, or gender. Also, unions cannot exclude individuals based upon those. It also prohibited sexual harassment. Now we know all these things still go on. And at the time, there was no teeth to this law. It said employers can't do these things, but there were no repercussions for actually doing them. So employees didn't really have any recourse. That's when the Civil Rights Act of 1991 was passed. That gave employees recourse to actually sue the employers. This applies to all employers who engage in an industry affecting commerce. So you see, once again, and employ 15 or more workers in each of 20 or more weeks in the current or preceding calendar year. Now, that means that not every employer is going to be subject to that. However, there are a lot of state laws on the books that would then come into play with regard to discrimination law. Civil Rights Act of 1991, this is when it provided compensatory punitive damages when the discrimination was intentional. So that's when employees were given the right to sue over any violation of the 1964 Civil Rights Act. ADEA is the Age Discrimination in Employment Act. Again, applies to employers engaged in interstate commerce with 20 or more workers. It says that states or employers, employment agencies, and labor unions cannot use age to discriminate in hiring, firing, or promoting. The age cutoff is 40, which is pretty young, but which is can be kind of surprising. Provides protection to workers over 40 years old. There are some exceptions. Executives 65 or older who have held high policy-making positions and are entitled to an annual retirement benefit of at least $44,000. I don't know why that cutout is there, but such employees can be forcibly retired. There are also certain industries where there can be forced retirement. Airline pilots, I think, are after the age of 65 have to retire. It used to be 60, not too long ago. But regardless of their abilities, there are certain industries where there is some forced retirement. Americans with Disabilities Act, a lot of us are familiar with this. I don't know if you're familiar with the fact that our Iowa Senator Tom Harkin, he's no longer senator, but Iowa Senator Tom Harkin was one of the original sponsors and authors of this particular act. We're all familiar with this, probably mostly because we think of, ramps, wheelchair ramps and accessibility and things like that, but it does a lot more than that. So prohibits employment agencies, labor organizations, labor management committees from discriminating against qualified individuals. So that's defined as persons who can perform the essential functions of the job with or without reasonable accommodation based upon disability. So it does have to be reasonable. Somebody with vision impairment is not going to be hired as a bus driver, right? So there has to be some reasonableness to it. It applies to the job application procedure, hiring, advancement, termination, compensation, job training, and other conditions of employment. So not just in hiring, as well through the life cycle of the employee. Again, reasonable accommodations have to be made. What is reasonable or not is usually left up to the courts to decide. What is a reasonable accommodation? Federal Personal Responsibility and Work Opportunity Reconciliation Act of 1996. I said this was a veterans one, I was wrong. This has to do with child support enforcement. So employers are required within 20 days of hire to tell a state agency that an employee has been hired, every employee has been hired, so that if they are required to pay child support, then that enforcement can commence, and employers will then be given garnishment orders for that employee. Okay, that was passed 1996. Immigration Reform and Control Act, IRCA. If you've been an employee, and it looks like most of you have, you probably filled out what's called an I-9 form. We're going to go into some more detail on that I-9 form. This is part of the Immigration Reform and Control Act. The I-9 form requires that you prove that you are eligible to work in the United States. You usually have to provide 2 forms of identification, and that has to be filled out. Those they don't get sent anywhere, but if immigration control enforcement comes into an employer, and they do surprise visits to employers, and those records are not on file, that can land the employer in a lot of hot water. Let's see. As they say, so immigration services can audit and levy civil penalties for hiring, recruiting, or referring violations. What else? Family Medical Leave Act, which you had mentioned here. So FMLA, which was passed in 1993. Again, it does not cover every employer. Employers with 50 or more employees within a certain radius, they're guaranteed 12 weeks of unpaid leave for childbirth, adoption, or serious illness of the employee or the employee's child, spouse, or parent. It's unpaid at the federal level. Certain states have paid leave. It can be used all at once or at separate times within 12 months. And the employer has to continue providing health care coverage, but the employee has to pay for it. They can mandate that the employee pays for it. Let's see. Uniformed Services Employment and Reemployment Rights Act. This is for the military. So the right for to military personnel to take leaves of absence for military service, and then they get to be returned to their prior, they're not guaranteed their prior position, but they are guaranteed to return with their accrued seniority. So they don't lose anything as far as their seniority, but so they get their original position or its equivalent, unless they've been dishonorably discharged, and then you don't have to apply that. ERISA provides protections for retirement income. So this is for companies that provide pension plans. Pension plans don't really exist all that much anymore. It's usually defined contribution plans, but ERISA helps to cover protections for those private pension plans and benefits. Again, I'm not going to go through all of that stuff with you. Affordable Care Act. A lot of you are probably familiar with this. This was passed in 2010. A lot of it's been watered down quite a bit, but this required that individuals who purchased health insurance privately couldn't be discriminated against based on health status, based on gender. There is still discrimination in premiums based on age, but those other factors are no longer allowable. It also initially provided a lot of requirements for employers. A lot of those requirements have been watered down subsequently. When it was first passed, employers with 50 or more employees were required to provide health insurance to their employees. That is no longer the case. Now there's still some reporting requirements for 50 plus employees, full-time employees or equivalents. All right, I'm gonna stop there because I want you guys to have a little bit of time. All right. So we went through, and I went through those very quickly. You'll read more about them in your book. I want you in your study group to spend, well, it's not going to be 10 minutes, but just a few minutes researching one of the laws that we discussed. So I'll put a list up here. So what did we discuss? We talked about FLSA. We talked about FICA. We talked about ACA. We talked about AD. I know I'm using the acronyms. ADEA. You can look it up when you're doing your research. We talked about FLMA. We talked about
USARA.
What's that?
USARA.
Oh, US. What is the
ERRA.
RRA. We talked about ERISA. We talked about FUTA / SUTA. We talked about FICA, income tax. I don't really have an acronym for this one. Anyway, so you can see the list here too. So ADEA, IRCA. Okay, use the next 5 minutes or so, and maybe I'll use the rest of the period to do this, and then on Thursday we'll come back. You guys can talk about it a little bit since this is a little bit rushed. So spend the next time researching one of those laws, find 3 facts about it, and then I'm going to ask you to share your facts when you come back on Thursday morning. Okay? So you can get it if you're not close to your group.